I am here. I'm the respondent.
You
Good
are
morning.
you're self-represented?
Yes, ma'am. Yes, yes, Your Honor.
Thank you.
Good morning, Judge. Easy Ilyansky for petitioner. The respondent is the movant here. This motion dismissed by the petitioner. I anticipate 20 minutes. We do not have witnesses, and I understand Mr. White, the respondent, the movant, might have one or two witnesses.
And it's not often that I see a motion to dismiss in family court. And so I'm going to ask another question here, even though it's still the announcement phase. Mr. White, what type of motion to dismiss? This is your motion to dismiss?
Yes, Your Honor. It's based on jurisdiction, Your Honor.
Oh, so it's a plea. It's a jurisdictional argument, basically.
Yes, Your Honor.
And do you have evidence?
Yes, it's in the box, Your Honor.
The thing that is the problem right now with the box for you is your exhibits, and I'm going to let my court reporter chime in here too, because you have some exhibit work to do. We can see your exhibits, but they aren't numbered. Like they're just sort of in there without numbers. At least that's what it looks like to me. So we may need you. We might start with the other case and have y'all back in a little bit, because we might need you to kind of do some exhibit work. But let me see if Ms. Racanelli can explain it, because she's better with box than me. Ms. Racanelli.
Yes, as I'm looking at your exhibits, it looks like you have like exhibit pay stub 1 and 2, but the other exhibits are just, as Judge Meachum said, they don't have numbers, are not labeled at all. So does that make sense to you, sir? Like you have screenshot, but there's no exhibit number. You have
yes, it makes absolute sense. And I woke up this morning and I put the pay stubs in there and I figured out how to name it so that it would fit the recommendation or the guidance you gave in the email. So I can fix those probably within 30 minutes and number them all. If you just give me the nomenclature you like, I can rename them in there.
Right. So if you could do them, I'm sorry, let me go back into that. So you're the respondent, right?
Yes.
So it would just, if you could just do like R-01, and then you could put a description if you like, R-02, R-03, you know, and then, but you can add your description on there too.
Okay.
That would help us, Mr. White. And so what I think I'm going to do is I'm going to go forward with the hearing in front of you. I don't know how long that hearing is going to need, but why don't I tell you and Mr. Ilyansky, if y'all could check back at 10 a.m. with me, y'all go out and he's going to work on his exhibits. Mr. Ilyansky, I think I see 2 exhibits of yours and they look like they're properly, let me make sure before I send you away. I just want to make sure. Yeah, I have a P1 and a P2. And that's all I have from you. And they're labeled correctly, I think. So I'll see y'all back at 10 a.m. Y'all can be excused. Come back at 10 a.m. and we'll have your hearing possibly at that time. I don't know what's going to be going on with this other case, but definitely check back with me at 10 and we'll tell you something then.
Understood. Your Honor, I have an emergency medical appointment today at 11:40 a.m. I can still probably do this using my phone. I just... It might be if the court allows me to do that. Is that okay?
Yeah. Well, let's hope. I think at this point, we're going to see you back at 10. Okay. And so maybe we can figure it out at that point.
Understood. I was just putting that out there.
Sure. I got you. But we have you maybe till like 11, right?
Absolutely.
Okay. All right. Then I'll see you back at 10 and we'll try to do this from 10 to 11. Thank you.
Judge.
Thank you.
All right. Now the next case is hold on, let me find you. It's Georgiuti and Potsakova, and let me see who's here on Georgiuti and Potsakova.
Good morning, Judge. I'm Michelle Locke. I'm the movement on the motion to withdraw. My client was notified and is not present.
Good morning, Judge. Peter Georgiuti. I'm the petitioner. I have 2 motions that I want to hear this morning. I have a third one that we can withdraw relating to passports.
Yeah, I did see that it looked like Judge Iserloh took care of the passport issue. I think she's already decided that and ruled and issued an order. So the question, I guess, is I see that Ms. Locke has a motion to withdraw. That's set and it's pending. And it sounds like we're prepared to go forward on that. And so then, Mr. Judy, my question to you is, what motions do you believe are set that that we are going to go forward with this morning? What are the actual names of the motions?
Yes, Your Honor, there's two motions for sanctions. One relates to a violation of the civil rules as identified by Judge Mousy on the 21st of November. The other is a motion for sanctions relating to a police report that Ms. Locke subsequently filed after that hearing, which was false, had no basis, and resulted in me wearing costs of a criminal attorney. So I'd like to hear both those motions. They were both announced last week.
Yeah, so I see two motions for sanctions that were filed on December 2nd. Are these the ones we're talking about?
Yes, ma'am.
It's just there's been a lot of sanctions motions in this case, so I want to make sure I can see the file and know what we're doing. And then, Ms. Locke, do you agree that those two motions are set today? I know you're not agreeing to what the content of them, but do you agree that that's what they're set?
I can't tell you whether they're properly said or not. That being said, I'm more than happy to address them with the court today.
Okay, so you're gonna, and since they involve things that happened while you're in the case, I think I'm going to hear the motions for sanctions first, and then I'll hear the motion to withdraw.
Whichever
makes the most sense for me.
However you want to do it, Judge.
Judge,
Okay.
do you mind if, and if that's how you want to go, that's fine. If you don't mind, the motions kind of relate to what has happened in the motion to withdraw, my motions that is. So I'm thinking if you're comfortable to do the motion to withdraw, a lot of what I'm presenting as evidence then covers in the subsequent motions, and I can just top up in my responses.
I mean, yeah, I guess so. I guess it doesn't matter what order we go. I'll let Ms. Locke go first, but let me let Ms. Racanelli get set up. And I guess what we're doing, we're not on the record yet, but she's going to get set up for the record. And then what we'll do is we'll just both have you argue, and you'll argue both at the same time. Basically, it sounds like Ms. Locke, you'll go first.
Thank you, Your Honor.
Both on your motion as well as responding to his motions for sanctions. Just, I'll let you argue first. Okay.
That's fine.
I'm going to take a quick couple-minute break while Ms. Racanelli gets set up, and I'll be right back. And in the interest of a child, this is Judge Amy Clark Meachum. We are here by Zoom by agreement on December 12th, 2024. Let me at this time take the announcements for the record.
Michelle Locke, on behalf of Valeria Pochkova, the movement on the motion to withdraw. We're ready to proceed, Your Honor.
Thank you.
Peter Georgiouti, pro se litigant. I have two motions for sanctions to proceed today.
As we discussed off the record, Ms. Locke, you are going to go first on your motion, as well as I think, as it's been laid out by Mr. Georgiouti, they all relate to each other, and so I'm just going to allow you at this time to both argue as the movant, but also as the respondent on some of the sanctions issues based on the pleadings that are in file in the court. So go ahead.
Thank you, Judge. I would like the court to take judicial notice of my first submitted motion to withdraw that was filed on November 7th, 2024.
I see that motion, and I will take judicial notice of it.
All right. And one of the grounds, I've asked to withdraw for reasons subject to the attorney-client privilege, but additionally, I am worried for my personal safety due to Mr. Georgiouti's actions. Mr. Georgiouti has harassed and threatened me and has sent harassing emails to my partners, associates, and staff during the pendency of the litigation. He's made false allegations regarding the integrity of my law firm, along with multiple Travis County judges. And I'm going to move to introduce, if I can, Judge, am I allowed to share my screen?
I think I've already given you that privilege. Give it a shot.
Thank you, Judge. I'm going to move to introduce R4, which is the email that I received 3 days after I had filed my amended motion to withdraw that I received from Mr. Georgiouti. So I'd move to introduce R4.
R4 is admitted.
And we'll get into some of the background of this case, Judge, is relevant to why we're here, why I'm asking to withdraw today. And so what was concerning me about this email was not the first paragraph. It was the second paragraph and second and third paragraph in particular. And I have filed a criminal complaint against Mr. Georgiouti based on this email, taken into context of what has happened before leading up to this email. And he said, it turns out I'm a highly trained and decorated soldier with nothing but a glowing record. I served in every special forces unit in Australia and another in the UK. I can't imagine
I'm sorry, Miss Locke.
I'm sorry, Miss Racanelli. I'm sorry.
Thank you.
I can imagine I have done things that are well beyond your wildest beliefs of what is possible. It has been a pleasure working with you this past year. It's a shame it has to come to an end. Don't be upset. I'm positive our paths will cross again, and I will be able to show you how appreciative I am of everything you've done to help. That is what I took as a threat, because if you look at previous communications, I'll ask the court to take judicial notice of the filings in this case relating to Mr. Georgiouti seeking to have the court disqualify me from representing my client. That was denied. He has sought my deposition. That was denied. He sought Miss Jane's deposition, my paralegal in this case. That was denied. He is sent to the county attorney's office. I'll move to introduce R8. If I can find my share screen again. And I move to introduce R8, which is the letter of April 3rd, 2024 that Mr. Georgiouti sent both to the county attorney and the district attorney.
R8 is admitted.
Okay. And in this email or correspondence he sent, he asked for an investigation to be open with the Texas Rangers into the relationships between myself and Judge Arth. And he goes on to basically say things about me that are inaccurate and false. But this shows his vitriol and anger towards me. And this is what has been consistent during the entire case. When we had a hearing in front of Judge Iserloh, and that was the last hearing we had, Judge Iserloh had to keep telling Mr. Georgiouti to change his focus from me to the case, because it was apparent to everyone in that particular hearing that his focus and vitriol was directed towards me. And so Judge Iserloh kept redirecting him and saying, Mr. Georgiouti, Ms. Locke is just doing her job. And so when that hearing ended, I was required to stay in the courtroom until Mr. Georgiouti left the courthouse.
The right people for the right thing. We also have gone live on our YouTube channel. Again, this case only apparently appears at duty week when I am duty judge, but I want to hear what's the latest, Miss Locke, because it's your because all these people do is come to emergency court and ask for emergency relief against the other. Sometimes the other side shows up, sometimes the other side doesn't show up. But it's basically how we've been functioning for a while on this case. So I'm glad to see an attorney. But lay out for the court what the relief is that you're seeking today.
Let me back up just a wee bit, Judge, just so you're aware. You signed, I think you will recall, temporary restraining order earlier or in late October based on Mr. Georgiouti's application. He had indicated to you that he provided notice as required by the local rules. That is only partially accurate. He sent my client, he sent her notice through OFW, which he knew she wasn't using at that time. She didn't have a valid subscription for it. So she was unaware of the hearing until afterward. She did not renew her subscription to OFW until the following week, because if you look at the orders, there were no orders at that time for the parties to exclusively communicate through OFW. And so she did not show up, not because she didn't want to, but she was unaware of it. That being said, we had a hearing in front of Judge Arth on the 1st of November. Judge Arth said that in the order, and I've got the transcript from the ruling, Judge, that she was to turn over all of her passports in her possession to me, because she's got Russians apparently have 2 Russian passports, and has to do with visas and traveling while you're getting a visa approved to travel somewhere else. It's allowed in Russia. She submitted her, and in fact, I have it here. She submitted the Russian passport in her possession to me, and this is the one that actually has her visa, visa to travel from the United
Is she
States.
right now? The other thought was she wasn't even in the country. Is she back in the country?
She is back in the country, Judge, and she was in the country at the time that you signed the TRO, is my understanding.
Okay. I've seen them. This is not my first introduction to this case. I saw them a year ago, I think, where we were still having these very difficult issues regarding citizenship and passports and what we're going to do. Because I don't believe, unless I'm wrong, that any of these people are American citizens. Correct?
That is correct. Everyone is not a U.S. citizen. In fact, the child was born in Malaysia. My client was born in Russia. Mr. Georgiouti is Australian. So no one has U.S. citizenship, which is another problem all on its own, but we'll address that at final trial.
Yeah.
That being said, we had a hearing with Judge Arth. The TRO, Judge, so the court is clear, has expired as a matter of law, period. It was not renewed. And in fact, I didn't really need to file a motion to vacate because he had not filed a motion to extend. I filed it anyways because I wanted to get in front of the court.
Mm-hmm. And
then Judge Arth ordered that she was to surrender any and all passports in her possession to me. Once that happened, the child was to be returned to my client. Mr. Georgiouti has a standard possession order. I think maybe expanded, but standard possession order, no more than that. And it is, if the court would take judicial notice of the temporary orders in this case, it is currently my client's period of possession.
Are we waiting on too, though, just to clarify, because Arth had seen this a couple of times. Are we waiting on an order from hearings of Arth, or is there anything that we're waiting on from Arth?
Yes and no. The judge made the rulings. There's a ruling prior to my appearance on enforcements. That enforcement order is still pending. I've not seen it from Mr. Georgiouti, and I'm waiting for the transcript from the court reporter on that. That does not in any way affect the possession or access. The temporary orders that were rendered a year ago are still in effect with regards to possession or access.
And your position is that nothing Arth is going to order is going to change that. These are all more about enforcement and about what's going to happen with the passports and all of those sorts of things.
Correct. And it's important to note that the child's passport is maintained by the district clerk's office. Neither party has access to the child's passport. And so the judge said once that she submitted the passports in her possession. I've got the transcript because he was very clear if she has it in her possession, she should surrender it. That is why I had her file the declaration that indicated that's the only one in her possession. And so our position is the child is being illegally restrained by Mr. Georgiouti. We have a temporary orders hearing or an additional temporary orders hearing because now Mr. Georgiouti is asking for sole managing conservatorship. And so we have a hearing set for that, I think on November 27th, it's the Monday following Thanksgiving. And so all I'm asking, Judge, that the child be returned to my client pursuant to the underlying orders are in effect.
All right, thank you. All right, Mr. Georgiouti, it's not going to help you at final trial. I'm just telling you, whenever you show up on Monday the 27th or whatever it is, it's not going to help you to not be following a court order. That's not a good look for you. But let me hear what you're responding to what Ms. Locke says.
Ma'am, I reject the idea that I am in breach of a court order. The first thing I will note, just to Ms. Locke's point, is I've just now provided evidence of a text message that I sent to Mrs. Positko in the interest of the child, and I'm showing you very, very egregious evidence, as I did with the TRO, that this woman absolutely intends to do this. She's gone on record in recordings which have been transcribed and submitted to evidence. There are admissions that she's admitted to, Your Honor. It is endless. It is a mountain of
Please
evidence.
raise your right hand, Miss. How do you say it? What's your client's name, Ms. Locke?
Porchkova.
Porchkova. Miss Porchkova, raise your right hand. In the testimony you're about to give, do you solemnly swear or affirm you will tell the truth, the whole truth, and nothing but the truth?
I swear.
Is your plan to flee with your child upon picking up your child tomorrow morning to flee to Russia?
No, I never was.
Are you living in a home? You can lower your hand. Are you living in a home with your mother in Spicewood right now?
With my mother, with my son, 15 years old, and expecting Aldo to be back home since 10th of October.
And your older child?
I have an older child. He's 15 years old,
And
who is the brother of Aldo.
Does he go to school here in town?
Yes, he's in high school in Lake Travis.
Okay. And then this younger child that the dispute is over, do you get that child to daycare and appointments?
Supposed to be in a daycare, but he's not attending, as I can see. And also, let me share one more thing. He is held in a totally third house for him, which is house of Mr. Peter mistress. It's not like it's a two house, so he's really stressed right now because it's not
But
mama and
you're
papa
listening to
house.
me. You don't have a
Sorry.
flight to Russia.
Yeah.
You're not going to Russia. You have no intention to go to Russia at this time. You
Your
are.
Honor, she says the UAE. It's not Russia. It's the
Oh,
UAE. That's
okay.
an admission. She
So you
specifically
don't.
says
You're not
the
going
UAE.
to the UAE either, correct?
What is your
The
European
United
Union?
Arab Emirates.
United Arab Emirates, I guess he's saying. And you're also
He's
not
saying a lot
traveling
of
to
things. Yeah, I wish we can have his passports, Your Honor.
Okay,
so
well,
I
we
can
don't
sleep
at this
quiet.
time.
Yeah.
This time,
Thank
this is
you.
what we're gonna do. Tomorrow morning at 11 a.m., Ms. Locke, we're gonna have this exchange at the DRO at the courthouse. And then
Judge,
we're gonna try to get to, but to your point, we're not gonna do another order. We're just gonna do the best we can, I guess. We're gonna follow the order that's in place. I'd be open to trying to figure out how to have less exchanges, but it doesn't look like that's gonna happen. So we're going to do this tomorrow morning at 11 a.m. at the DRO, mostly because it's going to take me a while to just get it arranged with them and to make sure they know y'all are coming. And
Your Honor,
we'll see everybody at that time. Thank you. Everybody is excused.
Thank you,
Can we make
Judge.
some provisions to get the second passport back?
At this time, no, the court's order.
It's in her mother's possession. It's just in
All
her
right,
mother's
you're
possession.
granting the writ, Miss Locke, and then we'll put in the writ that's when he's supposed to report with the child.
I will have the order submitted to the court, and I will include
Right.
Mr. Giorgiuti on the email.
Thank you so much.
Thank you,
Everybody is
Judge.
excused.
And I was required to stay in the courtroom until Mr. Giorgiuti left the courthouse. I was in the courthouse for an extended period of time because apparently, according to the sheriff's deputies, Mr. Giorgiuti circled the courthouse several times before they could no longer see that he was around the courthouse. Then I was allowed to leave. Another interesting part about this case is that Mr. Giorgiuti has somehow been involved in the passing out of flyers on cars at the courthouse. And I'll show you. I'll move to introduce what is marked as R7. And this, I'll move to introduce R7. These were flyers that were put out outside cars at the courthouse that Mr. Giorgiuti had testified to with Judge Iserloh that he was aware of.
R7 is admitted.
And I'm not introducing all of the evidence because there's a plethora of it, but to give you some of the background, Casey Dudley was on this case before I came on this case. And when I came on this case, I learned that Ms. Dudley obtained some kind of restraining order against Mr. Giorgiuti for actions that he did at her office. I have reviewed the cam footage from that, and it's actually been introduced into other hearings where he screams and threatens Miss Casey Dudley to such an extent that a restraining order was granted. When I came on this case, because I was aware of that and concerned because he was a pro se, I sent him a trespass notice under the Texas Penal Code, and I will show you what's been, I don't know what the exhibit is. Hang on one second, Judge. Move to introduce this as R6. This is the trespass warning letter that was sent to Mr. Giorgiuti on October 31st, 2023, when I first came on to this case.
R6 is admitted.
Thank you. And so
And I'm fairly familiar with the history. I've had
Okay.
this case on and off for 2 years myself, and had early matters with this case, I think before you were on it even. So I think I've been on my length on this case extends your length on this case. So whatever else you need to put in for you, the record, go ahead and put that in, but assume for the purposes of the case that I am well versed in the file and that I have taken judicial notice of the file as well as the history of the case.
it was shortly after that last hearing where I had to wait in the courtroom for Mr. Giorgiuti to leave the courthouse is when I truly became concerned. I don't scare easily. Death threats I've had before from, litigants. That's not really the issue. There's something different about Mr. Giorgiuti that gives me real concerns, and my career is not worth one case, and I have to get off it, Judge. I think at this point I'm a fact witness. Mr. Giorgiuti has stated in his motions for sanctions that I sought an ex parte protective order and it was denied. That's absolutely incorrect. I told Judge Mozzie that I was planning on filing a protective order application because I was concerned for my personal safety. This is a gentleman that came up to my ex-husband in court at one of the hearings and congratulated my ex-husband on all of his his murder convictions. And so he's done some kind of deep dive into my family history to even know that about my ex-husband. He's contacted former clients of mine and brought them to court to try and testify. I mean, he has gone above and beyond what a normal, reasonable pro se litigant I've encountered
And
has done.
your client, let's talk about your client for a minute, because I think a motion to withdraw is as much about your own client. And so you gave her notice of today's hearing.
Correct. We've sent her the Zoom link. We have communicated with her and she did not appear, but she has been notified. She was notified of the first December 12th hearing, and I'll get to that in a second. And then we reset that to this date, and she hasn't been notified of each and every step of the way of those hearings.
And you have been sending her the Zoom link for today, or we sent it to her directly, but
It was sent to her
made
directly.
sure. Okay. And so she has the Zoom link.
Yes.
And she is not here.
Yes.
Do you know generally, I know everyone in this case, there's an international component to this case. And so, and I don't want you to reveal any confidential attorney-client communications or anything that is confidential, but I want to understand if you understand that she knows about today's hearing or if you just have no idea.
No, she knows about today's hearing.
Okay. All right.
It's not a question on my end that she knows about today's hearing. I've seen the communications that my paralegal, Ms. James, sent to her, including the Zoom link. So there is not any doubt on my end that she has been notified.
Right. She's been notified, but you haven't actually spoken to her, it sounds like, in a while.
No, I have not.
All right. I just don't know if she's out of the country. I don't know if she's in a different time zone, in a different, I don't know currently that situation.
I can address that. I have her passport, and so she doesn't have the ability to leave the United States. And so she is still at her residence in Travis County, Texas.
And what are we going to do when you withdraw from this case? What are we going to do with the passport?
I have put in the order to withdraw an order for me to submit the passport to the Travis County District Clerk's office by a date certain, that the date that the court designates for me. The District Clerk's office is also holding on to the child's passport. So I'm following the same mechanism that a court has already ordered with regards to the child's passport. And that particular language is in my proposed order granting my withdrawal.
And other than what we have set today, what is upcoming in this case? What's currently set?
There's
that
a
you
jury
know of?
trial in February, I think.
So this case is currently on the jury trial docket with two pro ses and in February. Do you remember which date in February?
I can tell you in 2
It's 20,
seconds.
I believe it's 27, Judge.
It's the second one. All right. I just want to know from a court. Now I'm wearing my court administrator hat.
And we're
And
unlucky.
wanting to know. So, all right. There's that. I'm going to consider that Ms. Locke's motion. Is there anything else that you want to have the court admit before I go to Mr. Georgiuti and his response?
No, not at this time. I may have something additional after whatever it is he has to say. But I don't know if the court wants me to get into his motions or just wait for my response to whatever he says.
I think wait for his response. I mean, I think I looked at them. They're interrelated in some ways. And so let me turn to Mr. Georgiuti and hear his both response to the motion to withdraw and his motions for sanctions. Go ahead.
Yes, Your Honor. If I can just bring up one of my exhibits as it kind of details. I'm looking for, sorry. I'm looking for 33.
You kind of have the wheels of this now, but
Yeah,
I
this
can
is the-
see it.
Enter full screen.
I
found
mean,
it.
there you go.
There's some menus and stuff in the way. All right. Thank you very much. Just very quickly before I go through my response to the motion to withdraw, I'll carry forward into the details around the motion for sanctions. I just wanted to cover a couple of points on Ms. Locke's comments while I'm here, but she talks about harassing emails constantly. She provides one of these said emails, but says there's so many of them. You'll find the difference between my testimony and Miss Locke's testimony is mine has a lot of evidence to support it. Miss Locke's is essentially a story. Judge Arth admitted to the relationship that he has with Miss Locke and subsequently recused himself from the case. I have witnesses for all the claims that I have made to the Texas Rangers and the county attorneys. I have not made these things up, not the way Miss Locke does when she goes to the police. I have facts and evidence behind it, and I think that's what's so offensive to Miss Locke. She claims she's had death threats, and yet an innocuous email from me was enough for her to go to the police. It does sound very off-kilter, and I believe it's designed to just damage my visa more than anything else. The accusation that I was circling the courthouse, again, is there any evidence aside from just what Miss Locke is stating to be the truth? I left the courthouse with a witness. We went for lunch on that day. We were not circling the courthouse. And if we were, I suspect the deputies would have come out and addressed that, not just stood inside and waited to inform Miss Locke. The protective order issued around Miss Dudley was withdrawn. There was no jurisdiction for that. Miss Dudley was subsequently permanently removed from the case for the reasons that I went to her office to address. So there you go. Let me just jump into this. On the 25th of April 2024, I advised Miss Locke via email that I was obtaining legal counsel. This is Exhibit P2. I have a screenshot of that below. Miss Locke advised that she would not communicate any further and she would wait to hear from my new counsel. On the 3rd of May 2024, I sent 2 emails to Caldwell Bowles regarding discovery items and addressing a delinquency letter that had highlighted some discovery shortfalls. There was no further communication with Miss Locke or Caldwell Bowles from this point until the 7th of November 2024, when I received an email regarding their motion to withdraw. As per Exhibits P3 and P4, I chased my new attorneys to resolve a passport renewal process issue for Aldo's passport as per Judge Eisenlow's orders. It took 7 months and a request for an emergency hearing for Miss Locke to action this matter. Refer to Exhibit P17. On the 3rd of July, Miss Locke made a verbal offer via my legal counsel that I'm in agreement with in principle. It was put to me in an email, which can be seen in P5. But essentially, there's a path to completing this. On the 12th of July, my legal counsel chased up a written offer to support that verbal offer. This had already been promised and hadn't been delivered. And as per P6, we can see that my legal counsel was chasing up Miss Locke. Caldwell Bowles advised on the 15th of July that the document was being worked on and it would be delivered in the near future. As per P7, you can see I've highlighted that section there below. My legal counsel again chased Miss Locke for a written offer on the 22nd of July. And in this email, you know, my attorney is saying, I understand that you have had medical leave, etc., but you have staff supporting you, you have a whole firm there, you've committed to this a number of times. And then what I've highlighted there is another deadline, another reasonable deadline. Miss Locke responded on the 24th of July, committing that she would send it by tomorrow, after the above deadline, but nonetheless, tomorrow. On the 7th of August, I was advised by Mrs. Project-Cover in text that Miss Locke is non-responsive due to outstanding fees. After numerous requests by my legal counsel to get a written offer from Caldwell Bowles, they withdrew on the 14th of August 2024, unable to get anything done with Caldwell Bowles. I have all the emails to show their attempts to get this done. From the 14th of August 2024, nothing has been heard from Miss Locke or Caldwell Bowles until the 7th of November when they filed a request to withdraw. And that was Exhibit P12. That initial exhibit had nothing to do with all this threatening stuff that was added in on the amendment later when Miss Locke knew that I wouldn't be agreeing to her withdrawal and that I was requesting the above document. Per the email in Exhibit P13, I say exactly this. I advise that I am in favor of the withdrawal and I would sign the form upon receiving the current state of the written offer. I'm not expecting them to complete it. I don't expect them to see it through. I assume the document is in some state that myself and Valeria can take it forward and go to mediation and get it done. Per the motion for sanctions below, Ms. Locke failed to confer with me and scheduled a hearing for the 21st of November, despite numerous emails from me stating that I was both unavailable and offering 6 alternative dates. If you look at exhibits P20 through P26, we'll be looking at them below in the motion for sanctions. In addition to the above, Ms. Locke outright refused to send any settlement document, even though she had previously committed to this multiple times. In one of the emails, she even boasts that the court is not able to force her to send a proposal document. I sent a final request to Ms. Locke and her partners, which was ignored, and the hearing was scheduled regardless. I've copied her partners in this. Basically, the entire firm has ignored me multiple times in highlighting that the hearing should never have been scheduled. I am aware from Mrs. Pozhikova that she has given over $65,000 to Ms. Locke and her firm. And for this, we have seen absolutely nothing. Ms. Locke won't even share a document to support a verbal offer that we are in principle in agreement with. I'm very much in favor of Ms. Locke being let off this case, but not before she provides some sort of a workable document that allows us to move forward. We've been in this process for a couple of years. We've had more than one set of lawyers not do the right thing by us. What you'll note below is the type of excuses made by Miss Locke. I mean, she's just, she lies constantly. She's just egregiously dishonest. And when asked by the court if anyone from Caldwell Bowers could get any information why the passport didn't get action for sort of 7 months, her excuse is that she's had surgery for a couple of months. She doesn't like the way I talk to her, and it's my fault for not communicating with her, even though the first point of this argument was I advised her I had legal counsel, and she said she wouldn't communicate with me anymore. She made no effort to deal with my attorneys to get this done. She bundled the passport thing into a written offer, into a verbal offer, which she had no intention of giving a written offer for. So it's all just designed to waste time, run up those fees, and then go and withdraw when someone actually tells you to go and do the work. So moving forward into my motion for sanctions, on the 7th of November 2024, Ms. Locke breached the Texas Civil Rules and Procedures by setting a hearing without adequately conferring with the opposing counsel. This was further highlighted by Judge Mousy, who advised Ms. Locke on the 21st of November that she was in violation of those rules and procedures. I have provided a copy of the transcript. I have highlighted just one of the sections where that is relevant, but it does come up a couple of times. This is the part where it is identified as a violation. On the 7th of November 2024, Valeria Pozhikova's counsel filed a motion to withdraw. This was closely followed by an email requesting my signature on a motion. I responded that I'm absolutely willing to release your firm from the case and will do so if you can just send over the written offer that was committed to with my previous counsel. Caldwell Bowers, this was rejected. Caldwell Bowers then asked me if I was available on the 21st. Within 10 minutes, I believe, I told them that I was not available and that I gave 6 alternative dates. Ms. Locke advised me that she would be scheduling this regardless. She said she doesn't know what my objection to her withdrawal would be, and she doesn't care, and that she's going ahead with this anyway. I wrote back again as per Exhibit 23 to highlight that I'm speaking at an event in Denver. I asked her not to bully me, and I've offered 6 other dates. Ms. Locke further tries to convince me in P24 that everything she's doing is okay. She says the court requires us to confer, not to agree. And so she just uses these rules to her advantage and then comes into court and lies about what she's done to make it look like she's followed process. Despite my multiple emails to Ms. Locke and Caldwell Bowers identifying this incorrect hearing, the dates and all that type of stuff, they filed an amended motion to withdraw where they added in all the stuff about all my threatening behavior. And nonetheless, I sent the below email, which is P25, to Ms. Locke and her partners. This was ignored. Interestingly, the amended motion by Caldwell Bowers has a notice of hearing. This was signed by Ms. Locke stating that she made a reasonable effort to confer with the opposing counsel. Her actions show the exact opposite, and this was not part of the initial motion. Ms. Locke has knowingly acted in bad faith despite numerous emails and totally trying to bully a pro se litigant in this process while saying I'm the bully. A motion to strike was filed and upheld by Judge Mousy, with the reset date being scheduled for today, exhibits demonstrating that. Despite the setting being in violation of the local rules, Ms. Locke approached the court ex parte and conveyed a number of mistruths. Some of those I've just addressed at the front of this. After listening to the testimony and the request, well, it maybe wasn't a request, but the mention of a protective order, Judge Mousy reset the hearing and advised that no threat existed and hence no protective order was needed. After hearing Ms. Locke's list of things that she says happened, Judge Mousy
I'm going to
said,
object. Well, normally I don't, but that's an absolute misrepresentation of what Judge Mozzie said. And so if he wants to put in the
we have the transcript, Ms. Locke. I can finish. It's okay. We'll get there.
Let's not say what you remember Judge Mozzie saying, Mr. Georgiouti. Let's just move on from that, because the best evidence of that would be what Judge Mozzie actually said in her notes.
What about the transcript?
In the transcript, if you want to admit the transcript, then I will admit the transcript, but we're not going to, I'm not going to listen to either side tell me what a judge said.
Well, if I scroll down here, I've got a little excerpt here. I don't see how that's a protective order. I sort of grabbed it out, highlighted, put a red circle around it, because that's actually what happened, not what Ms. Locke believes did or didn't happen. So it is there. Based on this breach of the local rules and procedures and her intentional actions around this, I am seeking sanctions against Ms. Locke and her firm. I would also like her to be referred to the Texas State Bar for disciplinary action. I'll just continue and I'll finish up with this page if that's okay, Your Honor. It's relating to the motion for sanctions.
I just want to make clear, since you're pro se, that this court, while this court can refer people if it sees directly sanctionable behavior to the state bar, it's not an appropriate remedy, or not a remedy that a party can seek before a court of law. State bar action, that's not something this court orders.
Noted.
It's a whole different process that isn't part of this lawsuit. I just don't want you to be confused. That's not something you can seek from me in your divorce case.
Noted. Well, for the record, I will be filing an ethics complaint with the Texas State Bar in relation to all this stuff. So with or without the court's referral. So on November 21st, 2024, while in violation of the civil rules and procedures as identified by Judge Mousy in the transcript, Ms. Locke approached the court ex parte and discussed the potential of a protective order based on an innocuous email. She had received this innocuous email 11 days prior. Ms. Locke used my absent status to convey many mistruths to the court. As I mentioned above, after hearing the above evidence, and we can go through the full transcript to see how this was mentioned a couple of times, there was no threat. There was nothing to justify a protective order. Subsequent to the hearing on the 21st of November, Ms. Locke attended the Austin Police headquarters, where she filed a report for a terroristic threat using the same innocuous email as the basis for the report. She did this knowing that a judge had already ruled there was no threat associated with the email and that there was no imminent threat. I wasn't in the state. It had been sent 11 days before. We hadn't communicated in many, many months. There's also no physical threat in there. On Sunday, the 24th of November 2024, I received a phone call from a person claiming to be a detective with the Austin PD. The man proceeded to issue a verbal cease and desist and made accusations that were untrue and unfounded. He referenced an email about my military record as the primary reason for the call and said any further correspondence with Ms. Locke would be met with a harassment charge. Upon advice from the police headquarters front desk officer, an Officer Cutler, and a callback officer on 311, a complaint has subsequently been lodged with the Police Oversight Committee, Office of Police Oversight. A case manager has been allocated and the issue has been flagged with APD Internal Affairs. It appears that standard policing processes were not followed in this incident. I have a follow-up call next week. Further to the below, I became aware that an arrest warrant was also issued and recalled. The arrest warrant was issued November 22nd, the morning after Miss Locke made her complaint at police headquarters at 7:30 p.m. at night, and it was subsequently recalled on the 26th, as you'll see below. I believe that the above actions were designed to harass and intimidate. I believe Ms. Locke knowingly filed a false police report 11 days after the emails received in an effort to disrupt my visa renewal process that is currently underway. Ms. Locke is still the attorney for her client, and her actions are not in the best interest of her client or my son. On the 5th of December 2024, I hired a criminal attorney who has since spoken with the judge and the detective and confirmed that the matter is closed. The cost of this was $1,000 as per the receipt below. I'm very keen to know what was said to the police in the report that led to the detective going for an arrest warrant in such a timely manner. According to the police, this doesn't make sense unless the detective was misled to believe that there was an imminent threat. I would like to cross-examine Miss Locke to understand what was said to the police, because the police report is fully redacted, but I'm going to guess there's some details in here that may not be that accurate to make the police act the way they did. So am I able to put Miss
No,
Locke?
we're not going to have evidence, and we're not going to have testimony this morning. I think just put in whatever exhibits you want to put in. I'm going to review them. I'm going to take the motions for sanctions under advisement, and think about what to do, mostly because there are obviously lots of issues happening here. But now what's about to happen is this case is going to be completely managed by a judge, because we're going to have pro se versus pro se, and we're going to have to get more involved in how the jury trial is going to work.
You're on.
And then there's a lot of thought in my mind
You're on. There's not
about,
going to
no,
be.
listen to me. Do
Sorry.
not talk over me. You
Yes,
remember this from previous hearings, Mr. George Judy. Do not talk over me. The court reporter cannot take it down, and she's going to take what I say, not what you say. What I'm saying to you is, I'm going to have to think about whether or not this matter all goes before a jury or doesn't go before a jury, because it's such a side matter to the actual fight about the conservatorship of the child. And there's a lot that's going to go into this case from a judicial perspective. And I don't want to rule any way that limits or restricts one of my fellow judges when they try this case in February. And so what's going to happen now is a lot of thought and consideration by the court on what this case is going to look like at final trial, because I do believe y'all need to get to final trial. We need to get the conservatorship issues tried, and we're going to have to try them. But all of this, just thought has to be given on what sort of consideration we're going to do, because it's obvious there's really not a fight about whether Ms. Locke is going to get out. Everybody is in agreement. Ms. Potsakova's not here. You're basically in agreement. She wants out. And so the motion to withdraw is going to be granted. But what's now remaining is this ongoing vitriol, and how that's going to play out at the trial, because it's true, Ms. Locke might be a witness at the trial, if called by Ms. Potsakova. So we have to think about all of that. These are complicated, complex issues, and it's now going to be on the court, because we're going to have two non-lawyers figuring all of that out. So no is the answer to whether or not you can call Ms. Locke today.
Okay.
But I don't want to keep you from admitting evidence. So the evidence you have loaded that you feel like you want to ask the court to admit, I want you to get to that, and I want you to go through them. Anything you want the court to review.
Your Honor, just very quickly on that, myself and Mrs. Pozakova are in daily communication. We're actually on very good terms. So we don't foresee the need for a jury trial. We believe that we can have an agreement in place, soonish. We need to start working on that. And so we have a plan forward that will not very likely involve or need the courts. Obviously, an agreement that we agree on, we want the court to legalize and whatnot. But I'm not anticipating the need for the January trial. I'm not expecting to be in front of the court, consuming the court's time for anything other than by agreement orders with me and Mrs. Pozhedkova, which I'm very happy to say after all these years.
That sounds great, but it's not going to change what I'm going to do today. And maybe, if to your point, if y'all do work on an agreement and you do reach something, that would be something that I'd want to know about. But for now, I'm still going to take the sanctions motion under advisement because I am not ready to rule on it today. Thank you.
No.
So what do you want to offer and have the court admit? Because I think a lot of this is attached, or some of this is attached to the sanctions motion, and you pulled it into the sanctions motion itself. So what do we need to do today to give the court all the tools the court needs to make a decision on the sanctions?
So I think this document I'm looking at, which is P33, this is obviously the core of my submission, and it contains a lot of information in here. It does also reference these other exhibits. Do I need to specifically tell you to add them into evidence, or like how does this?
I mean, I think this P33 looks like it's almost like a summary. Is that fair to say? I think P33 is a summary.
It is, ma'am. And if someone looked at this and said, oh, I'm really interested in what the details of P6 are, for example, they can go into, like, do I need, the P6 is in the box and it's the full email thread. This is all extracts and whatnot.
So understanding that P33 is summary, Ms. Locke, I'm on the verge of admitting P33 as a summary. And it appears to pull from other documents, some of which contain hearsay. I understand that, but to shorten this hearing, I am inclined to admit, I guess R33 is what this is.
No, it's P.
It's P33? Okay. Ms. Locke?
I think my objections are, it's under optional completeness. Everything should come in, but I understand the court's ruling on it, so I understand my objections overruled.
Yes, the objection's overruled. And this is R33, and R33 will be admitted. And then the other thing that's going to happen here, Mr. Giorgiuti, I want you to understand another option is rolling some of this into the final trial. Now, I hear what you're saying. Maybe y'all are going to reach an agreement, and that would be lovely because this case has been hanging around the courthouse for 2 years now, but it needs to be an actual agreement. And it might be the sort of thing that I'm just telling you, if an agreement is reached, the court might call you down to the courthouse anyway, or at least have a Zoom appointment where I can at least talk to both of you and figure out if this is a real agreement, ask you some questions, and make sure you both understand the tenor of the agreement, because now you're on your own. Are y'all talking to a mediator, or are you just talking to each other?
No, so it's more to each other, but our plan is to involve a mediator. We're not sure if there's like a single lawyer attorney that can help both of us together as opposed to a me versus their attorney, but mediation / someone, yes, absolutely, Your Honor. And we want to come back and we need to be ratified by the court. I will note that it is unlikely this agreement will end up in an actual divorce. It's more likely to be a post-nuptial agreement to do with visa statuses, etc. So we have a path forward. We've figured a whole bunch of clever stuff out. Our case doesn't fully align to how the court functions because of the international aspect. We get that.
We said that from, I remember day one, we talked about that. So,
and here we are. And look,
it's an issue the whole time.
It has been, but I think now Mrs. Pozhedkova has a job. Mrs. Pozhedkova now has a life here. Her eldest son is doing exceptionally well in high school. Our little one's in kindergarten and he's happy. We just went on a little trip to Houston to sort out the passport together. Like, everything is very functional now. And so removing Miss Locke from the equation, I think, removes a lot of the drama and hassle that we've had in this process. And then we will be able to move. But I do reinforce this point. Why is Miss Locke not being pushed to give the document that she committed to in so many emails? I just pointed out, what's the point in saying, I'm going to give this tomorrow, I'll give this next week, I'll give this sometime, and then it doesn't exist? That's got to be a lie. That's got to be fraud. That's one of the reasons why I keep going to the county attorneys and whatnot, because Miss Locke.
Well, I have the other case coming back. I'm saying I'm going to take this in advisement. Ms. Locke, why don't you take like a minute or two to respond to what you feel like needs to be responded to with what Mr. Giorgiuti just said?
Sure.
But not a lot, because I need to move on to the next thing.
I understand. Real briefly about the settlement. and it wasn't even a settlement, nor was it something that I said to his attorney was something we can do. I was trying to option generate ideas. And so I option generated the idea with his attorney of a post nup, which is interesting what they're using now. The problem is, and this is why I couldn't send it, is that I believe that that would be violations of immigration laws because it's done for the purposes of avoiding immigration issues. And so as an officer of the court, I can't send a proposal like that. I just can't. And so that became the issue. Well, I could not send that proposal and did not send that proposal. And I didn't have my client's authority at the time to send that proposal. But I can't go into all those details, nor am I going to with Mr. Giorgiuti. So that's really that's it. For him to say that I've lied and misrepresented is, I mean, simply inaccurate. I'm an officer of the court and I take that very seriously. Mr. Giorgiuti is welcome to file whatever he wants to at the state bar. I'm not worried about it. I just need to get off this case.
Well, I'm gonna, I don't know, Mr. Giorgiuti, if you've put in a proposed order into the box or not. I know Ms. Locke has. I think it's just denial of the motions, but I know there's also the motion to withdraw itself that I need to get to and get signed. How have you provided the order to the court, Ms. Locke?
It's in, I think it's in
Box.
Word format, Judge. It should be in box, but let me verify with my paralegal.
And will you send it to me?
At the submission?
Yes, the submission is what I would prefer.
We will send it right now.
Copy Mr. Giorgiuti. Thank you.
Yes,
And we'll
yes,
get
Your
that
Honor.
order signed. And then any other orders that you want the court to consider, which would be denials of the motions for sanctions on your side, Ms. Locke, as well as granting motions for sanctions on your side, Mr. Giorgiuti, as I take this under advisement, and what sort of sanctions you would be asking for. I'm a little unclear about that. But I also, I appreciate that you and Ms. Potsakova are working on something. And so that sounds like a positive development in this case. And so anyway, keep us posted. But for now, I'm going to take the motion for the motion to withdraw is granted. I'm going to sign that order today. The motion for sanctions is taken under advisement, and I would like both sides to get me proposed orders to my 201 submission email for those proposed orders on the motions for sanctions. And at this time, we're going to go off the record, and this hearing is over, and you are both excused. Thank you,
Your Honor.
Thank you, Your Honor.
We are proceeding under our remote rules by agreement of the parties. And so at this time, let me take the attorney announcement for the record, and then we'll take the self-represented announcement for the record. So first, the attorney.
Easy Ilyansky for petitioner non-movant, Ms. Semedo.
Thank you.
Richard White, pro se.
And I believe you're listed as respondent, and that's how you've uploaded exhibits.
Yes.
But you are the movant in this particular motion. So you're going to go first, Mr. White.
Okay. Well, thank you, Your Honor. I put the motion forward to dismiss this original petition based on jurisdiction, Your Honor. Over the last 9 years of living in the Austin area, the petitioner and I lived as husband and wife only in Williamson County. We never lived anywhere else. During that time, I have uploaded a lease, R-04 of the property that we shared. We're both signatures on that lease, Your Honor, and the lease did not end until after the petitioner filed.
My apologies. I would object to any exhibit that's not from which foundation has not been laid on.
I'm not admitting any exhibits yet. It's opening. And so he can refer to exhibits, but we're not going to admit anything yet until we get to a little bit further into this. Thank you. And then, all right. So Mr. White, I just briefly, before we're not going to do your testimony yet. It might mean some repetitive nature of this, but briefly, you've brought a plea to the jurisdiction, a motion to dismiss based on what? Based on the wrong county. They filed that you say everybody, no one in this case lives in Travis. No. Not at the time it was filed. And so At one point, there was an earlier filed case, and that has been non-suited. So you referenced FM 23-3104, and that was a lawsuit that you all filed. Somebody filed a petition for divorce, but the status in our records are that case is closed and that it was
Yes.
non-suited.
Yes.
And then is there also a pending case in Williamson County?
No.
So the only current pending case is this case.
Yes.
That's helpful. And so, but you want it to proceed not in Travis, but where?
Williamson County. Well, we're going to have to discuss that, Your Honor, because I've since moved out of the area. So that'll be something I'll have to get advice on. I'm no longer living in the Austin area. So.
All right. Well, that makes it hard because courts don't generally dismiss cases if there's nowhere to send them to. You kind of have, it's a difficult process that you're in right here. You're in a strange procedural situation, even if everything you're saying is true. And there's a lot of family code that deals with this type of issue of where cases should be filed and what's the proper jurisdiction and what's the proper venue and all these different things. But let me hear from Mr. Alansky, and then maybe we'll get into some evidence on this issue as well. Mr. Alansky.
Yes, Judge. Good morning. My apologies. I'm a little bit under the weather today. So, first of all, Ms. Sumit is not here today. It is my understanding that she has been hospitalized. So essentially it's going to be just me. We do have several exhibits, but what had happened is that back in April of 2023, Mr. White filed a divorce in Travis County under the previously referenced cause number. He was the petitioner, and the petitioner was the respondent in that case. In that case, he states on the record that he's a resident of Travis County. That case was not sued by Mr. White. We immediately refiled into this case the same day of the non-suit or the day after. And then on October 1st, 2024, Mr. White filed a counter petition wherein he again says that he's a resident of Travis County, has been in the domiciliary for 90 days, et cetera, et cetera. Judge, under KJB, which is a good case law that I've uploaded to the box, a statement in the petition for divorce that the petitioner satisfies the residency and domicile requirements is considered a judicial admission. The matter therefore becomes moot. If Mr. White is going to testify that he did not live in Travis County at that time, we'll cross that bridge when we get to it, I guess. But we have evidence to show otherwise, and that's where we are.
All right. So at this point, Mr. White, I'm going to swear you in. And if there's evidence that you want to put in the record, you can put in the record for purposes of your motion. So please raise your right hand and be sworn in as a witness. In the testimony you're about to give, do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
And again, I'm just going to go forward and say here, I'm not going to dismiss a case that I don't know where it's going to go forward at. And so the family code gives me a lot of emergency jurisdiction, a lot of kind of secondary or jurisdiction for cases that have nowhere else to be. And it sounds like, Mr. White, you're not willing to tell me where you are or where these cases should be. And so I just want you to keep that in mind. You've got to give me something that sends it somewhere. I don't just dismiss it in a vacuum. Even if everything you're about to say is accurate, there's got to be a follow-up plan for a situation like this one. And oftentimes the follow-up plan is where it's filed is where it sticks, unless somebody gives me a better, a more persuasive jurisdictional place for this case to be. So keep that in mind. And then let's get to your exhibits, which I think you've re-uploaded now, and your testimony. Go forward.
Yes. So I have several pieces of evidence, proof of my residency that I filed. And they can be looked at in any order. The first one I put in is RO1, that's the lease, I'm sorry, RO4, that's the lease agreement that we have that shows the residency. And both the petitioner and I are signed on that, and it didn't end until May of 2024.
Okay, well, this is a 2020 lease that you signed in 2020, right?
Yep, and it went all the way through, and we extended and ended in 2024.
And you're offering just the lease itself. He's offering the standard lease agreement, Mr. Alansky, as Exhibit 4.
Yes, Judge, I would object on 901, lack of foundation.
Overrule that. I'll admit 4. Keep going, Mr. White.
Also, I've added Exhibit R07, I believe, which is my bank statement, which also puts me at the same address, Your Honor. In addition, I have my IRS statements, which were mailed to that address as well, Your Honor, as well as 2 pay stubs during the time period that the
Now, where is this address? In Round Rock, right? But now you're saying you're no longer in the Round Rock address.
I live in Fort Bend County, Texas, Katy, Texas.
All right. So at one point, for an amount of time, you lived in Round Rock, but yet you filed for your divorce here in Travis.
Yes, I did. That was an error on my part, not being a lawyer. I did not understand. I went and read up on the case and how things were supposed to be, and that's why I'm here today. You're supposed to file where you're actually a resident for the last 90 days. So that's what I'm speaking about today. And Your Honor, the reason that I even had what Mr. Lonsky is referring to is anything to do with Travis County is because I was locked out of my residence by the petitioner. The keys were taken and the mailbox keys. So I had to have somewhere to get my mail. That was a P.O. box. That's the only evidence he has that I was in Travis County. It was a P.O. box that I used to collect my mail because the petitioner has testified that she locked me out and took the mailbox keys. So I had to put my mail somewhere, had to get it somewhere. That's why he's referring to this Travis County. I have no other lease in Travis County. Everything, my car insurance, everything was Williamson County.
All right. Well, that is his argument on the motion to dismiss, I think, Mr. Alansky. So what would most of this is going to be based on the pleadings, I think, and any sort of evidence he just said, which is that he never lived in Travis. He doesn't live in Travis now. He used to live in Williamson. Now he lives in Fort Bend. So how would you respond either legally or factually to that, Mr. Alansky?
I'll respond legally, Judge. Again, because I don't have Ms. Sametos here today. First of all, I want to clarify that when Mr. White says that he was not a lawyer when he filed the original case, that was the one that was dismissed, that was actually filed by an attorney on his behalf. In the counter petition that was filed in this case was also filed by an attorney on his behalf. So both of those state that he is a resident of Travis County, has been a domiciliary in Travis County for the last 90 days. That being said, Judge, I'm going to give the court a very brief overview of what happened. I'm going to be very brief. Back on April 4th of 2023, Mr. White filed this divorce under a different case number. That's the case number that ends in 003104. Mr. White was the petitioner. The petitioner was the respondent. We've included that in the box as P1, Your Honor. That's a true and correct copy of the petition. We move to admit that, please.
P1 is admitted.
Thank you. Petition states under page 1, paragraph 4, that Mr. White has been a domiciliary in Travis County for 90 days. Pursuant to INRI KJB, that's a 2023 appellate court case out of Dallas. I've also uploaded that to the box and highlighted the relevant opinion. The statement in the petition for divorce that a petition satisfies the residency and domicile requirements is considered a judicial admission and the matter becomes moot. Now, Mr. White non-suited that case on April 10th, 2024. On that non-suit, Mr. White again listed an Austin address as well. We even uploaded P2 as the non-suit believe either motion or order. I'm not looking at the box right now, Judge. It's a true and correct version of that. We move to admit P2, please.
P2 is admitted.
Thank you. Now, what happened was Mr. White filed this non-suit the same day that we filed discovery, right? So it was, I believe, an hour later. So on October 1st, 2024, I'm sorry, after he non-suited the case, we filed this one. And we served Mr. White. And then October 1st, 2024, Mr. White filed a counterpetition in this case. We would ask the court take judicial notice of the counterpetition filed on October 1st, 2024, please.
The court takes judicial notice of the file.
Thank you. Again, first page, paragraph 4, the same thing. Mr. White has been a domiciliary of Travis County for 90 days. We fall back on INRI KJB, a statement in the petition for divorce that the petition satisfies the residency requirement and the domicile requirement is considered a judicial admission. The matter then becomes moot. Now, if the court does not wish to entertain that Mr. White if the court rather does wish to entertain the fact that Mr. White lives outside of Travis County, we've uploaded some relevant case law. First, we go to Cotton versus Cotton and Flores versus Melo Palacios. We put both of those cases in the box. And this is a good and current case law that simply states that the court acquires jurisdiction over a resident respondent who voluntarily makes a general appearance, and a person is a resident of Texas if he's physically living in the state. Mr. White is a Texas resident. That's not contested. Mr. White has made a general appearance in this case. He's pled for affirmative relief without filing a special appearance or otherwise challenging jurisdiction. The matter becomes moot that way as well. In regards to the lease, Your Honor, what had happened is Bluffwood, I believe that is the lease that Mr. White is referring to, is the marital home where Ms. Samedo and Mr. White resided. At a certain point, Mr. White moved out. I don't have Ms. Samedo to testify as to when. At that point, Mr. White went to live somewhere else. Ms. Samedo continued living part-time at Bluffwood. At part-time, based on information, believe she lived with, she might have been living with her adult children in Travis County, but I don't have Ms. Samedo to testify about that, so I can't really say. Regardless, Your Honor, the evidence provided by Movant is not convincing. The judicial admission made multiple times by Movant is controlling. And even without that, the Movant himself availed himself to the jurisdiction of this court by virtue of his counterpetition. And like Your Honor, you just said, there is nowhere to move this case to anyway. We don't have any other filing in Williamson County, in Fort Bend County, or anywhere else. As such, we ask the court deny relief brought by the Movant today. Thank you.
So I'm about to give a lesson in civil procedure, Mr. White, and I recognize that you didn't go to law school. But here's the thing. The concepts of jurisdiction and venue are actually different concepts. It almost sounds strange, I'm sure, to somebody who didn't go to 3 years of law school. Sometimes for people that even did, sometimes for even judges. But the truth is, I think this is the right answer, civil procedure wise. I have jurisdiction, and so a motion to dismiss this case on jurisdictional grounds is denied. There is a question about whether I have venue or not, but you have not brought a motion to transfer venue, and you have not brought a motion that is proper and pending before this court. If a motion to transfer venue is filed, the court would have to consider that. But as to the question of jurisdiction, the motion to dismiss this case on jurisdictional grounds is denied. Hear what I'm saying. If a proper venue motion is filed, the court will have to take that in consideration. Mr. Alonsky did not say where his client lived, and she's not here to testify. So I'm not for sure what the answer to that is. But as today, based on everything you said, Mr. White, you do not get a motion to dismiss on jurisdiction because jurisdiction and venue are different concepts. And I have jurisdiction because this is a case in which the state of Texas definitely has jurisdiction. It may not be a case that the Court of Travis County has venue, but that's a different concept. So as to this, the motion to dismiss this case is denied. I hope all that makes sense. I tried to give you a fulsome ruling so you could go out in the world and both Mr. White and Mr. Olansky could hear what I'm saying. I have jurisdiction. May not have venue, but that's not the motion that is currently on file before the court.
I understand, Your Honor. Thank you. I do want, just for the record, I do want to say that I never moved out of the residence. I want this to be clear. I was locked out of the house. Locks were changed. Mailbox keys were taken, Your Honor. I never moved out. My possessions, and I continue to pay the rent and the lease payments on that house up until the day, over $100,000. So I just want that, because Mr. Olansky said I moved out. I never moved out. I was locked out with no notice.
I hear you. I hear that additional bit of testimony is said. It sounds like there might be a discussion that Mr. Olansky and Mr. White need to have offline about where this case needs to be. But nevertheless, the court deals with motions that are pending before the court, and this one is denied, and everyone is excused. Thank you.
Judge, do you need an order, or are you just
If
going
you
to?
want to send me an order, I will sign off on an order. Yes, but it will be very limited as to what I say.
Right, understood. Thank you,
Okay.
Judge.
Thank you. Y'all are excused.
Have a good day.
And we can
Thank
go
you.
off the record and we can go off of the YouTube at this time.